Thank you. Mr. Sachs.
Good morning, Your Honors. Peter Sachs, Assistant Attorney General for the State Board of Retirement and the other appellants. The question here is whether the 6-year statute of limitations for actions in contract under Chapter 260, Section 2 bars the State Board of Retirement's administrative implementation of the pension forfeiture statute, Chapter 32, Section 15.4, against a former state representative who was convicted of crimes related to his public office. And the answer is no. This Court
Even
said
though the statute's changed? Now the statute's changed, correct?
The statute was changed in 2004 to require state prosecutors to give notice to PERAC when public officials have been convicted, and PERAC will then presumably notify.
I just have one question. The members of PERAC don't read the newspapers?
No.
Well, I gather what you're getting at is whether the State Board knew about the conviction at the time in 1996. And whether they did or not is really irrelevant under the McLean case. There's no evidence in the case one way or the other about that, and the Town of Nantucket versus Beinecke case said that's not a proper subject for judicial notice in determining when public officials know whether they have a cause of action. But even if the Board had known the moment of the conviction, that wouldn't make a difference, because under the McLean case, Section 15.4 forfeiture is a mandatory requirement that follows by operation of law from the statute and the conviction itself. It cannot be waived even by express agreement with the member of the retirement system. 15.4 says, in no event shall any member after final conviction.
Well, doesn't that, I mean, can't that be interpreted to mean just that the state can't sort of give up that remedy by, agreeing not to seek it? But does that really mean there's no limitation on the period during which the state can bring the action?
Well, if it can't give it up by agreeing not to seek it, then it's difficult to see how the state can give it up by mere attention or passage of time.
Those are very different things. I mean, someone's getting a pension for 20 years and all of a sudden the state says, hold on for a minute. We hear there was a conviction 20 years ago. We want it all back, plus this, plus that. I mean, how is that fair?
The legislature has addressed that in another section of Chapter 32, Section 20, subparagraph 5C, which requires errors in the Board's records to be corrected and requires payments to be adjusted.
This is not an error in the Board's record. Is it really? This isn't that kind of error.
It's an error in that the Board's records show that he's entitled to the pension, and he is not. And 25C, I should point out, is a two-way street that benefits members as well as boards. If a contract statute of limitations applied, then if a member discovered an error after 6 years, if the member were relegated to an action in contract limited by Chapter 260, Section 2, then if 6 years had passed, the member couldn't require the board to correct that error.
So it just seemed to me that section really had to do with sort of mathematical errors or calculation errors, not, whoops, you weren't entitled to a pension, or you did something at some point that you lost entitlement. That's not the kind of error. At least I don't read it that way.
It hasn't been interpreted that way, and it benefits the member as well as the retirement board and the other members of the retirement system whose assets are involved to have Section 25C available to correct errors no matter how long ago they occurred. If you applied a contract statute of limitations, the member would be cut off after 6 years, or in this case where you're dealing with the State Board of Retirement, and it's a 3-year statute of limitations for contract claims against the state, a member could be cut off after 3 years.
If someone how would the statute of limitations apply if someone learns that there's been a mathematical error in the calculation of his pension? That he continues to get the wrong amount every single month. So there's a new error, in essence, every month,
But he couldn't go back and get the money that he was entitled to.
Past 6 years.
Yeah, and in the Holstein case decided by the appeals court, the retirement board, it was I think the Boston Retirement Board in that case, had gone back and corrected errors 24 years old and had paid refunds to members. If
Is that
the
because was that a contract action? I mean,
No,
I mean, why did
no,
they do that? They
it's
could
not
do
a
that.
contract action. The errors were discovered, brought to the attention of the board. The board may have discovered the errors themselves. I don't know. But the errors were corrected without the need of any breach of contract action.
Right. I mean, the board can do that, I assume, can find out it made a mistake and determines that, in fairness, they ought to correct it.
Well,
I don't see how that applies.
Section 20 requires boards to correct errors, but Section 20, subparagraph 5C, also creates criteria for a board to waive recoupment of past overpayments if certain criteria are met. The criteria are laid out in the statute. If the board misapplies them, the board is subject to review for abuse of discretion.
But I thought you're telling us that the board cannot waive revoking someone's pension who's been convicted of a crime that's covered.
It could not waive it prospectively. It could waive recoupment because Section 20 subparagraph 5C authorizes it to waive recoupment if those criteria are met. Mr. Woodward never requested that it waive the recoupment here. So the legislature has dealt with potential unfairness by enacting these provisions that allow waiver of recoupment if the criteria are met. But certainly that would not excuse a board from applying the forfeiture prospectively. The reason that Chapter 260, Section 2 doesn't apply, aside from this being covered by Section 20, subparagraph 5C, is that the board's implementation of the forfeiture is not an action. This Court has said that the term action as used in statutes of limitations refers to actions in court, not arbitrations, not administrative proceedings before state agencies.
But I thought we set a statute of limitations for State Ethics Commission administrative proceedings. That wouldn't be an action either.
That was the Zora case, Your Honor, and in that case there was no actual discussion or resolution of the issue whether a statute of limitations applied at all. In that case, both parties agreed that some statute applied. The only dispute was over which statute applied, and this Court agreed with the Ethics Commission that the longer statute applied, and therefore the action wasn't time-barred. But the question whether statutes of limitation apply to administrative actions generally was not actually litigated there, and this Court could have reached the same bottom line there by holding that no statute of limitations applied because it was an administrative action. This issue of whether Chapter 260 statutes of limitations apply to administrative proceedings wasn't actually litigated in Zora. So there's nothing inconsistent about that case and this one. This is not an action that the board took or that the board initiated. This is not an action in contract, which is what's covered by Chapter 260, Section 2. While the Section 25.5 of Chapter 32 says that the provisions of Section 1 through 28 create a contractual relationship under which the member is protected in the core of his or her reasonable expectations. This Court and the Justices and the Appeals Court have consistently recognized that's a very special and limited kind of contractual relationship that exists only in order to give the members protection against impairment of their statutory rights. Essentially, it says this is a contract for purposes of the contract clause so that the legislature can't reduce benefits or raise contribution levels for people who are already in the system. But that provision about the provisions of Section 1 through 28 creating a contract does not mean that the provisions are enforceable through an action for breach in contract. If that were true, then all of the work that retirement boards do, all of the work that CRAB does in reviewing retirement boards, the work that PERAC does.
Well, no one is suggesting, I don't think, that this is a purely contractual relationship. The only issue is whether, for purposes of determining the essential nature of this particular interaction, it's more contract-like than anything else. I mean, we've done that selectively because it does say it establishes a contractual relationship. I know it's not the same.
Well,
but
it's contractual for the purposes of protecting the members' rights from legislative impairment. It is not contractual for purposes of enforcement. The enforcement is done administratively through retirement boards, through CRAB, through PERAC, always subject to judicial review, of course, but not through actions in contract. And Chapter 32, in 5 other places, gives retirement boards or governmental units, and I quote, an action in contract in order to recover certain monies. But that's always against, at least in the case of retirement boards, always against other governmental units. In no instance does Chapter 32 create a contractual right or an action in contract for a retirement board to recover money from a member. So the legislature said action in contract 5 places in Chapter 32, but not in Section 15.4, so it shouldn't be read in there where the legislature didn't put it there. And Mr. Woodward doesn't claim, notably, that any prejudice resulted to him from the absence of a limitations period here, either to him or in general. He doesn't claim that there's been any loss of evidence or that he's been deprived of the ability to argue against the forfeiture, nor would there be any such prejudice or loss of evidence in the ordinary Section 15.4 case, because all the evidence that you need is in the record of the criminal proceedings. Here are the proceedings in federal district court. And as for prejudice in having to repay, that's been addressed by the legislature in Section 20, subparagraph 5C, where the legislature essentially strikes a balance. It says if the member meets certain criteria and asks the board to waive recoupment of past amounts, the board in its discretion can do that. But there is an interest on the other side, which is the interest of the other members of the retirement system in the preservation of the system's assets. And the legislature struck this balance in Section 20, subparagraph 5C, which there would be no reason for a court to disturb. Now, the question might arise, is there really no limit on how far back a retirement board can go? Obviously, Section 20, subparagraph 5C allows a board to waive recoupment, so that's, in a sense, one limit. Ultimately, due process might provide some limit if a member argued and there was some basis to conclude that the member had been prejudiced by the passage of time in his or her ability to defend against the or to argue against the forfeiture. And if you really wanted to stretch, if you concluded that this was an action or had to be brought as an action, which we would strongly dispute, then conceivably one could view this as an action on a judgment, since it's the judgment of the judgment of conviction that triggers the forfeiture. And actions on judgments are within an exception to Chapter 260, Section 2, which refers you back to Chapter 260, Section 1, and has a 20-year statute of limitations. But we don't think the court needs to go that far. We don't think this is an action at all. The very provision of Chapter 32 that speaks about members being convicted of offenses related to their office or position does not say a member shall not do this and then relegates the board to an action in contract to seek damages. The very provision that says that talks about conviction says, if you're convicted, in no event shall you be entitled to receive an allowance. So Mr. Woodward's statutory entitlement to receive these benefits ended when he was convicted, even though the board erroneously did not implement that until more or less 6 years later.
Can I ask you just one question about, so your position is that, in fact, there is no statute of limitations governing administrative proceedings unless one is specifically built into the statute. So the Ethics Commission, in spite of the cases that we've decided, there's just no statute of limitations issued there because it's not an action.
Well, I don't think the court has to go. Well, yes, in order to rule our way here, you would need to rule that this is not an action. You don't need to make that ruling about other state administrative agency proceedings because the language in their statutes might be different. And I should also point out that even if you did conclude that this was an action, the final conviction here did not occur until less than 6 years before the board took steps to implement the forfeiture. So even if you rule that Chapter 260, Section 2 applied, we should still prevail because although the jury came back more than 6 years before the board began to implement, Mr. Woodward filed a motion for a judgment of acquittal. That motion was not acted upon for some time, for some months. When it was denied and he was sentenced and judgment entered, was less than 6 years before the board implemented the forfeiture. But we would urge the board, this court, not to rule on that narrow ground without reaching the larger question of whether 260 Section 2 applies, because we have at least 4 other cases that we've cited in our brief in which this issue of the timeliness is coming up. And if it's not resolved in this case because of the quirk about when the jury verdict was versus when the judgment of conviction entered, then it's going to come back here in another case.
Mr. Sachs, could I ask you just one question? I don't think you filed a reply brief, right?
No, we did not.
I mean, there's no reason for you to. Did you pay any attention to the 260 Section 5 argument, which is sort of tacked on at the end of
I believe that deals with forfeitures
Right.
given to
Penal
the Commonwealth. That says that forfeitures, actions for forfeitures given to the Commonwealth have to be commenced within 2 years
Right.
after the offense, I believe.
For forfeitures under a penal statute.
For forfeitures under a penal statute. That's not applicable here because Section 15.4 is triggered not by commission of the offense, but by a conviction. And if you apply Chapter 260, Section 5, then the forfeiture could become time-barred even before the defendant was ever convicted, because it may be more than 2 years between the offense and the conviction. So for that reason, Chapter 260, Section 5 would not apply.
Thank you, Mr. Sachs. Mr. McCormick?
May it please the Court, with me is Elizabeth Maitland. The instant matter, if I could address the Chief Justice's last question, we would say that while this was not before the district court and the trial court, 260 Section 5 may well apply. As this case is said in Gaffney, that this, for at least interpreting the statute, 32 Section 15, that it is penal in nature, and then did not comment. In Gaffney, in footnote 3, this court states that Section 15.4 is penal for purposes of statutory construction. We construe the statutory language narrowly. We intend no comment on the penal character of Section 15.4. So we would say that that may well apply. But before this court today is whether the 6-year contractual statute of limitations apply.
What do you do with the language in no event, Mr. McCormick?
Well, I read my brother's brief, and it's interesting that the cases they cite for their argument that no event means never, it doesn't matter what happened, are from Texas and Arizona. Because I don't see any cases from Commonwealth, Massachusetts.
How would you, if you wanted to say never in the statute, how would you say it?
I don't think you can. And I think that's what's the great thing, because there is no automatic consequence. There is no never. There is no event. If we look in that little saying that is out on the wall in this brand new courtroom, it says a fair administration of justice by an impartial court or an impartial jury. The conviction that 32 Section 15.4 talks about, it isn't just a conviction. If Mr. Woodward had been convicted of jaywalking or drunk driving or larceny, shoplifting at the Walpole Mall, I doubt would be here. There would be no forfeiture proceedings. The legislature specifically said it must relate to his official duties and responsibilities. That requires, I would suggest to the court, that there has to be some finding by the State Retirement Board that, in fact, the conviction upon which they're basing their proceedings did, in fact, relate to his official duties and responsibilities. Otherwise, if we use the word never or no event, the provisions of 32 Section 16 have no meaning. There is no judicial review. There's specifically Section...
I'm not with you, Mr. McCormick. You need to take more baby steps to get me to go with you.
Could I ask it, to address it this way? As I understand it, as we've said in prior cases, the in no event means, at least among other things, that this cannot be settled, it cannot be waived, it cannot be disclaimed by the State. And what is your response to the argument Mr. Sachs briefed that is, well, this would open up a way to settle them and waive them by simply being passive for over 6 years? It would allow an end run around those prior cases.
And let me just ask you one question. How do we know that isn't exactly what happened here?
I don't know that if it did or it didn't. I can answer that if we take a look. How did they know? And let me answer the question this way, if I might, and then address that question more specifically. We know why they started it. It's in their brief, It's because of newspaper articles in the Boston Globe in 2002.
Suddenly they're reading the paper, and 6 years before, they're not reading the paper.
I would suggest they would have been reading the paper all the time.
But isn't that a concern for this court? Because while that, you may interpret that in your client's favor, what that suggests is that the legislature did not want to make this discretionary. It wanted a fair administration, which is that anybody, doesn't matter who you know or whose brother you are and whether you have a connection, anybody who's been convicted under this kind of conviction, and you can make that determination at any point, you forfeit it.
Well, Your Honor, that's a good question, Your Honor, but I would suggest to the court that applies to everything, because it would appear...
No, because if, one defense to a criminal prosecution is not, but everybody else does it.
No, Your Honor, that's true. But there's certainly discretion on a district attorney or an attorney general or a U.S. attorney. They make discretionary decisions all the time whether to bring a prosecution or not.
And they have every right to do that, right?
Yes, Your Honor.
And if the legislature wrote a thing that said, in no event will you not, if you know about a jaywalking thing, will you not prosecute, it probably violates Article 30, but that's a different issue. But here the legislature, this is the legislative area, the legislature said, we're going to give A, B, C, D, E, and F pensions. Those are the only people who get pensions. G comes along and says, I look just like B, too bad. I mean, unless there's some, equal protection violation. But here they've said, but you're not, if you do these kinds of bad things and you're tried and you're convicted of these kinds of convictions, you forfeit it.
Well,
and I don't want to have whoever's sitting on the board, whether that's deliberately, turning a blind eye or not reading the paper that morning, or it's not in the paper, or they just don't know and they don't have the, somebody to go down and check the dockets.
Well, Your Honor, if I could answer that by answering it hypothetically with the amendment to the statute. Now the district attorney or the attorney general has to give notice to the state retirement board if they're becoming aware of these convictions. And let's say the attorney general, the state retirement board, then does nothing. Does nothing, as Justice Cordy said, does nothing for 20 years.
And then the Globe Spotlight team runs another series, and then it seemed to me that one thing that the board could be saying is, this is any conviction. I mean, a conviction by any tribunal, correct? Any tribunal.
I would not agree to that it would be any tribunal. I think a final conviction would be of a criminal offense.
Yeah, that's
I think
what I mean.
the only criminal offense could be at any court.
It could be any court, right? So it could be a federal court, it could be the Springfield District Court, and the State Retirement Board is saying, you expect us to, keep track of all of those things, so at least help us. At least help us.
Well, Judge, how much help did they get? They had 6 years. This was on the front page of every newspaper. Everybody knew this. Everyone went on. Because when we talk about, I take the questions, is someone going to be shown favoritism? And that is what we're trying to avoid.
Correct.
Let's put the shoe on the other foot. Is someone being not favored, but is someone being picked on because it was an election year and the treasurer was running for governor in 2002? And that's what really happened here. The Commonwealth admits as much that they got this information in the 2002 newspaper articles. And there was a series of Globe Spotlight teams on a bunch of convicted felons still receiving the pension.
No, I understand that, but let's assume that the legislature has anticipated that, saying we can't get into the motivation. And so what we're going to say is nobody, in no event, nobody gets it. Then if for some reason somebody doesn't pick it up for 5 or 10 or 15 or 20 years, we will give the board discretion as to whether or not you seek recoupment. But we're not going to give them discretion as to whether or not you forfeit it.
Well, Your Honor, I think unfortunately, if the court is concerned about possible favoritism in having discretionary powers in not seeking recoupment or not bringing the action, aren't we really doing the same thing? Because what we're doing is waiting forever. Someone could wait forever. Justice Cordy had his question was exactly on point when I want to argue this court. At what point does fairness enter into this?
Well, then you bring then there's a claim for recoupment, and then the lawyer comes in and says, this is terribly unfair. they've known about this for 25 years. Here's my question. The forfeiture of a pension is an extremely costly circumstance to somebody's life. I mean, a pension, state pensions tend to be for the remainder of somebody's life. I mean, they have enormous present, very high present value. People plan their lives, their families plan their lives. This is not a casual decision by the legislature, not a casual decision. And it seemed to me that one of the things that the legislature was doing is to say, it's so serious that we want to make sure that everybody is subjected to it, no matter what.
And I think everyone is. Everyone is subjected to the same statute of limitations, and everyone should be subjected to the same statute of limitations. The statute of limitations should apply to Mr. Woodward. It should apply to the Commonwealth of Massachusetts. It applies to everyone. Everyone knows what the statute of limitations is. Everyone knows. I would suggest to this Court that its decisions in town of Nantucket and Zora and the other cases talking about statutory, I would presume the legislature is presumed to know that. But as long as we're talking about statutory, to get back to Justice Sussman's question, in no event, let's take a look at some other language that's in this statute. The decision of the district court shall be final. Yet here we are. So certainly because the legislature there said we don't want any judicial review of the district court, that district court decision shall be final, and that's it. Yet this court, obviously, in the McKenzie case, has interpreted that language to say, but that you still have a right to petition for certiorari. So, Your Honor, we can go either way here, because there's certainly...
But that's because there's a certiorari statute.
That's correct.
So the legislature has told us that the word final means final except for the very limited scope of review available under the statute authorizing certiorari.
Not to belabor the point, I don't think the legislature told this court that. I think this court told the legislature that. And what we have...
And they didn't change it. And we usually take that, correctly or incorrectly, to mean they agree with us. They may or may not, but they can fix it. Right?
But I think to get back to this, if this court is going to hold that any statute that the legislature may enact uses the words "in no event," what happens when the legislature puts in, as we see a lot of new laws coming in, a lot of more stricter laws, perhaps restricting the rights of criminal defendants? In no event should a murder appeal go to the Supreme Judicial Court. In no event shall an armed robbery be appealable.
But there would be there's no constitutional claim here, is there?
I think there is.
Have you made it?
Well, it didn't have to, Your Honor. I won real quickly down below, so I never got there. But certainly, Your Honor, if we look at the McGrath, I believe it's the McGrath case that I've cited in my brief, talking about Mr. Woodward, or any pensioner, has a proprietary interest and has due process requirements and has due process protections to keeping that pension. And I would suggest to the court that while I don't necessarily think the issue of in no event is before you, but that in no event language by a legislature certainly runs afoul of due process considerations.
Unless you take the position that a member is on constructive notice of the statute saying in no event, and so every time he cashes his check, he knows he's incurring an obligation to the Commonwealth.
Yeah, but Your Honor, you could take that the next step further. Because I'm on notice of a statute doesn't mean I have to live by it. Doesn't mean I agree to it, or doesn't mean I can't challenge it when it comes right to me.
But that issue really isn't before us, at least not yet.
The no event issue.
The constitutionality.
A due process claim is not before us.
No, Your Honor, that was not decided at the district court. The no event, it was strictly a summary judgment on a 6-year statute of limitation. That was the only decision by the district court.
And what you're suggesting is the in no event language doesn't preclude this court determining that there is a statute of limitation that applies. It may mean a lot of other things. For instance, the Commonwealth cannot settle or disclaim the forfeiture provisions, but that really doesn't speak to the statute of limitations.
Exactly, Your Honor. That's exactly
Mr.
right.
McCormick, this is not before us, and if you choose not to answer the question, it's fine, but it strikes me because even before the amendment, there were obligations placed on the Attorney General and the District Attorney and everybody else. Would there be some problem with saying to everybody who's receiving a state pension, tell us if you've ever been convicted of anything and tell us if you are convicted of anything going into the future. We will then make a determination as to whether or not it's related to your job. You don't have to decide that. You just tell us.
It's part of an annual certification.
Well, I think if I were writing that statute, I would say there's going to be a real lot of wiggle room and problem with that, because who's going to decide whether that is a conviction that fits?
No. I'm saying don't do that. Don't you convicted of anything, jaywalking, final conviction. You tell us. You tell us.
Well, you want to? Are we then? And I would suggest to the court, no, I don't think that should be an obligation on an individual citizen, because a person works for the state and collects a state pension, are they then going to have further obligations that, say, a person in the private sector does not have?
If you are sitting in Gillette or Polaroid or General Motors, your pension doesn't quite mean what it means these are state funds. These are
I know, Your Honor,
big
I sit at McCormick and Maitland, and I have no pension, so, but
you should call Mr. Sachs and see if you can exchange jobs for a while.
I think that would be, Your Honor, once we start putting
I'm not. It sort of leapt out at me, because even if you put the obligation, on the district attorneys, how is the Attorney General or the district attorney going to know of whether this is a circumstance which comes within the meaning of the statute? It seems to me a strange way to go about it, but it's not my decision.
I have another question for you. I haven't quite worked this out in my mind. I just thought about it. But if you say that this is a statute that's subject to the 6-year statute of limitations because it's a contract, what about every time the member cashes his check? Does that renew the statute of limitations?
I think under the hypothetical that Justice Cordy was talking to my brother about, I think it would, because it's like a continuing breach of contract. If you say you're going to deliver a round widget and you continually deliver square widgets, I think every time there's a square widget delivered, it's a breach of contract. However,
No.
I'm sorry.
No, I'm asking if it doesn't extend the statute of limitations in favor of the Commonwealth, because he's cashing his check when he's on notice that he's in violation of the statute.
There was no requirement, then, Your Honor. I think then we're putting a burden on Mr. Woodward that has never been placed, not placed by the legislature, not placed by any court decision, rule, or regulation. You're placing in him on a burden on him that has never been placed on anyone and was not required of him. And I think that would be, creating a obligation on one party to the contract that was not set forth in the contract.
Mr. McCormick, the reason why I asked you about the notice provision is that your attack, at least in your belief in the no event, seems to suggest that what the Commonwealth is arguing here, or the board is arguing, is that there's an automatic forfeiture. And I don't take that to be the board's position. I take the board's position to be, of course, you've got to have some kind of adjudication as to whether or not the conviction falls within the requirements of 3215.4, that it's related to the job. And that's, it seemed to me, what those cases were addressing, not whether it can initiate the procedure to determine whether or not it falls.
Well, I wasn't sure. I looked at the language in McLean, and when I saw the word automatic legal, the phrase automatic legal consequences, that's what I was addressing in my brief. But as far as notice, that may well be up to the legislature, and the legislature may take that prerogative. But it is not a requirement in this case. It was never a requirement of Mr. Woodward to so do that. And in a very practical sense, Your Honor, to answer that question, Mr. Woodward's name in headlines on the front page of the paper for several weeks. Is he then required to then write a letter to the Board of Retirement, hey, take my pension away? I don't think that obligation is on any party to any contract. When one party breaches a contract and supplies the wrong widgets, it isn't up to that party. That party has no obligation to say, hey, you know what, I'm not sending you.
No, but you're
you wanted.
proceeding at your risk.
You're proceeding at your risk for those 6 years. Yes.
Well, if you've got a decision from the, either, that makes it clear, or from the court saying for 6 years only, but,
Well, and I think, absolutely, you're proceeding at your own risk. You know you're doing something wrong, or you may not know you're doing something wrong. Because the other thing here is, keep in mind, to answer that question, keep in mind that if we look at the totality of the circumstances of Mr. Woodward, there were other defendants being charged in the similar type areas. The First Circuit overthrew one of them out on Mr. Sawyer, and there was a question. There was a question at that point: what was going to happen to any of this? But certainly, the conviction came in on October 2nd of 1992, and even the government has says that, for purposes of the argument today, that should be the date you should consider.
thank you, Mr.
Thank you very much.
All right. Hear ye, hear ye, hear ye.